And first up, it is time for a keynote on what is dictated by law when it comes to AI. And she was here also last year, and now we are lucky to have the leading expert on in Europe on this topic return to this stage. This time she will give her take on the ethical and regulatory considerations of AI in media, providing an update on the AI Act. Please welcome Professor of Law and Digital Technology at University of Amsterdam and co-founder of AI Media and Democracy Lab and Head of Research for Humane AI, Natali Helberger.
Thank you so much, and it's really great to be back. I'm really looking forward. So we have an AI Act. In March, the European Parliament voted, and soon the celebratory tweets went out from the European Commission that Europe is now a global standard setter in AI. And now, to begin with, I really hope that somewhere here in the audience is a documentary maker who would like to make a documentary about the making of the AI Act. And Dali suggested this could be the poster to announce the film. And if any one of you thought that law and policy is boring, then I invite you to dive deeper into how this law was made. It's a story of passion, of power, of intrigue, of traitors, conspirators, and heroes. With stars like Ursula von der Leyen, the ambitious head of the European Commission, the fearless fighters from the European Parliament fighting for citizen rights and fundamental rights, the mysterious Cedric O, lobbyist, France, who almost derailed the entire act, Sam Altman, of course, tech giant, and Luca Bertuzzi, a fearless reporter with whose reporting the whole process would have been much more opaque. But more about this later. Before I update you what has happened since we last spoke, briefly, why should you care? We heard a lot about how you all use AI, how you use generative AI. We also heard about the challenges of integrating AI into work practice, a lot of technical challenges. But did you know, actually, that the ethical and cultural concerns weighed as heavy as the technical challenges, according to a report from Police from last autumn? And that is a finding that we actually saw in our own data. Nick referred yesterday to the report that we wrote together with Associated Press, which was published yesterday. And among others, we asked our respondents on their various strategies for the ethical use of generative AI. And by the far most prevalent strategy was not to use it. So, in other words, when a majority of your newsroom workers have ethical concerns about the use of AI or Gen AI in a newsroom, and if the prevalent strategy to deal with these concerns is not to use it, you begin to see how ethical concerns or a lack of solutions for these ethical concerns can actually be a serious inhibitor for innovation. What are these concerns? And again, we specifically asked about concerns with generative AI. By far most important concern is the lack of human oversight, followed by concerns about quality, inaccurate information, bias, plagiarism, lack of accuracy. It's also interesting to look what concerns are not mentioned. Ecological footprint, concerns about the power of big tech, flooding our public sphere with synthetic content were not about the concerns mentioned. So this is a whole picture of, when talking about concerns about Gen AI in the news industry, it's still a very inward-looking picture, and this is something we might want to think about. Looking at these concerns mentioned, what is common to many, if not all of them, is that they highlight this particular democratic and societal role of journalism for the content it's produced. So this is a quote from a study, interview study that we did about responsible procurement in the lab. If we make an error over in marketing, who cares, right? A few pixels wrong here or there doesn't matter, we just fix the error. But if we use a fake picture or write errors in the news articles, this is a very different story because we have a different responsibility. And essentially what speaks from this quote is the importance of having trustworthy technologies, trustworthy tools that you can rely on. And this is actually exactly where the law can make a difference, by addressing these ethical concerns and by this way also promoting the uptake of AI. And this is also exactly what the AI wants to do. The goal is to address the risks from the specific uses of AI and make sure that Europeans can trust the AI they're using. You might recognize this picture from last time because nothing has changed in that respect. It's still maximum harmonization, which means this law, once in force, will apply in all European member states. It's extraterritorial effect, which means it also applies to large technology companies from outside Europe if they offer products and services here. And it's a risk-based approach. And Ezra already hinted briefly at it, risk-based approach, it means there are certain applications of AI that we consider so risky for fundamental rights, for health and safety, that we ban them. Certain forms of emotional recognition, but also think of social scoring. Then there is this orange category, that's high-risk systems. There's a list, an annex, where the European Commission lists the different sectors in which we consider the use of AI very risky, with a consequence of rather far-reaching regulations about data quality, about training, about the obligation to enable human oversight and transparency. Media are down there in the green area. So they're not on this list, high-risk list. There are a few exceptions, like the use of AI in HR and biometrical categorization. So for example, if you use biometrical categorization to recognize faces or persons in pictures, this might fall into the high-risk category. For the rest, no rules apply, almost no rules. And this is good and bad news at the same time. It's good news because it means fewer legal obligations for media organizations using AI and also for developers developing journalistic AI. It's bad news because the law is not setting any guardrails for journalistic AI, so you will not be able to rely on the AI Act if you wonder yourself whether the technology you're using is trustworthy or not. So for now, probably the rules that are most relevant for you are the rules about generative AI, and this is what I will talk in the remainder of my presentation. And there are three ways how I believe the AI Act can be somewhat relevant for the media. Transparency as an antidote to deepfakes and synthetic content, media content as training data, the whole copyright debate, and trustworthy Gen AI. Let's start with the first. So one major concern around generative AI is synthetic content, deepfakes, the possibility to flood the internet with pictures that are not real, like this fake image of the ex-President Trump that his supporters have unleashed on the internet. And the AI Act offers two lines of defense here. The first is that providers of Gen AI systems, so those who make the systems, OpenAI, Anthropic, Mistral, they will have to ensure that all generated output is labeled. And Meta has actually already started doing so, if you might have seen. And ideally, that must help users, but also journalists, editors, social media platforms to identify generated content. The big question is, how effective is this? How easy is it to circumvent? And what is actually authentic? Secondly, those using AI in professional practices, journalists and editors, they must disclose for all images, audio, video, and text with the purpose of informing the public on matters of public interest that content has been generated with or manipulated with AI. And this is one of the few end-user facing obligations. The goal is to help consumers understand if a content is authentic or not. And that taps into discussions that you also had already yesterday. What should we inform users about, and when should we inform users? Only the transparency obligations, the editorial media is excluded from these transparency obligations, at least for text, and for audio and video only if it's not evidently artistic. So does that mean that there's no legal obligation for the media to be transparent? Yes. Does that mean there's no moral obligation for the media to be transparent? No. In research that we did at the lab, we found actually that more than 60% of a representative sample of the Dutch population would feel manipulated if they were not informed about the fact that the article was written with AI instead by a human journalist. And this suggests a striking need for transparency, even if it's not legally mandated. We also found, and that I found interesting, that by simply informing users that this content is generated by AI, this does not give users a lot of information, whether the content is actually qualitative, artistic, trustworthy, or not. So the big question is actually how to inform them effectively. And this is follow-up research that we do at the lab right now. And there are also some exciting initiatives happening here in the Nordics that Agnes will talk to you about in a moment. So I will park the topic for you now. But two important lessons you can draw from that for the AI Act. The first one, a law like the AI Act can only set a certain minimum standard, especially if it's a law that is as political as the AI Act. So you also need to think how to go beyond compliance, for example, if you want to keep the trust of your users, as the industry has been doing over the last years with a lot of new ethical guidelines emerging. But laws like this and ethical guidelines, and that's the second lesson, are only the beginning. The real work starts in the authorization of very vague norms. So how to inform people, for example. To the second topic, how the AI Act can potentially help or address the media, and that is the entire discussion about training data. You probably, or some of you will have followed the controversies in the US. New York Times is suing OpenAI. And here's a quote from the article: "Defendants seek to free ride on the Times' massive investment in its journalism, using the Times content without payment to create products that substitute for the time and steal audiences away from it." So that's a bit the discussion that is going on right now. And in Europe, we see OpenAI approaching Springer, LP, Le Monde in a typical conquer and divide strategy and making deals. At the same time, the French competition authority just imposed a fine on Google because BART had used content from French publishers, failing to propose technical solutions for the press agency to actually opt out. And that refers to copyright law, where publishers have the right to opt out from their content being used as training data. And I know that some of you have also done so. But this whole question whether to opt out or not, and now comes the slide, is the topic that very much divides the industry. And again, this is something that we've seen in our survey with ERP, where we actually ask people, should other organizations be allowed to train their models on news organization digital content? And the biggest group of respondents is really torn. More than 50% said maybe. Arguments against are copyright issues, transparency, but also how to protect journalistic integrity and fairness. For example, like one of the respondents say, why would you actually teach a competitor how to replace you? Those arguing in favor of sharing are a bit more optimistic about the ability to strike a fair deal and point how the cooperation with LLMs could actually advance the field but also make society better. The training data needs to be accurate and well sourced. Training models with garbage will sink us. So those are different positions, but they remain theoretically as long as the media don't have ground to stand on in negotiations. And this is again where the law comes in. In Europe, copyright law, as I just mentioned, foresees the possibility to opt out. And where media have opted out, LLMs will need to negotiate for a license. The question is how to know that your content has been used and how to operationalize your right. So exactly the point in the French case. And here the AI Act says two things. Offering solutions to technically opt out from being used by LLMs for training will become mandatory, and all large language providers will make publicly available a sufficiently detailed summary about the content used for training, according to a template provided by the AI Office. And again, much will depend on how this template looks like, because already the lobby is on, with LLM providers trying to use trade secret rights to keep as little information as possible, and rights holders and civil society arguing for more detailed information. So if you wonder what you would like to do or should do in the context of the AI Act, joining the debate before the AI Office on this template might be an idea. And then the infamous rules on Gen AI as my very last point. So last year when we talked, there was considerable confusion where exactly fit generative AI in this high-risk, low-risk category. And also we were not certain what kind of risk we're actually talking about. And we also didn't want to discourage a new technology. So there were different positions. The Council would only regulate high risk. The Parliament wanted to have actually a lot of rules that would have also addressed some of the concerns we thought about ethical accuracy, bias, and so far. In the end, this whole debate led almost to a derailing of the Act. So what happened? In the very last moment before the technical meeting, suddenly France, Germany, and Italy protested against any rules on generative AI. And especially France was in the lead. Mistral's, and here Cedric O comes in. He actually, together with others, put a lot of political pressure on the French government to oppose the rule, to favor so-called European champions. And Germany, with Aleph Alpha, its own model, and Italy, they actually joined the protest, and they didn't want to have rules. And these are powerful countries in the negotiations, with the effect that the Parliament left the session earlier, and it was only after a hardcore 36-hour marathon that actually parties agreed. And essentially, they agreed on skipping most of the obligations proposed by the Parliament and leaving it to a transparency regime. So the European champions had won. Ironically, 2 months later, Microsoft indicated they invested in Mistral. So there was actually a lot of suspicion and discussion towards, and headlines like Trojan horses, how European startups teamed up with big tech to gut the AI Act. So it was actually a really exciting story. Okay, so what came out of this? What came out of it is actually that all large language models are more or less not regulated, except the need to document some technical details about the model, the purpose of the model, the way it was trained, and the transparency provisions we talked about later. And only high-impact foundational models with so-called systemic risks have further-reaching obligations. Only they have to actually test their models and do a systemic risk analysis and mitigate systemic risks. And these high-impact models, ironically, are only US companies. So actually the threshold is so high that at the moment it's probably only BART and OpenAI, ChatGPT. What does that mean for the media? Again, it's good and bad news at the same time, I suppose. For those media organizations who would like to build their own models, the AI Act is not going to stand in their way. Almost no rules, unless they become really, really large. For media who use third-party models, the picture is a bit different. There are very few legal safeguards, except for these very large models, which ironically could have exactly the opposite effect than the law wanted, to drive users into the arms of big tech. Positive thing is that there are probably more attention for systemic risks for the sector. Again, talk to the AI office. And maybe more choice. So the question is, and that was the whole purpose of the Act, let many models bloom, especially European models. But will that happen? Or do we tumble further down the big tech rabbit hole? And that is actually a question that very much depends on you and the choices you make and how critical you make these choices. So will you go with the first AI model that comes along and is big and easily accessible? Or will you ask some tough questions? And the data is not very optimistic. So, and you see, of all strategies for ethical use of generative AI, responsible procurement is at the very end. This is really something to think about. And of course, I understand it is also difficult, and there are high search costs for testing and evaluating different models. But I do think that if you want to benefit from a diversity of models that maybe, for example, also optimize for smaller languages, for accuracy, for data quality, then I think we need more responsible procurement. So my argument would be, or my statement, or my encouragement for you would be, responsible AI really starts with responsible procurement. And in the last year with the lab, we did interviews with media professionals and asked them what are the aspects we should look out and you look out when you procure technology. And we compiled these in a checklist that we developed. I was part of a member of a commission for the Council of Europe and published, so you can find it here. Some of the arguments we already talked about, the quality of training data, but also issues of reliability. So say you use a model and it spews out content that is either infringing copyright or data privacy, who's liable? And if you look into the terms of use of a lot of these models, it's the users who are liable, because these terms of use are used to shift all the liability. Some models actually promise to help you with the court costs. So that is something you might want to look at. How was the model developed? How much effort was there in de-biasing the model? Where is the data stored? Europe? Zanzibar? US? How easily are these models be used and enable you to exercise human oversight, which we saw was a key ethical concern? How much support? Is there actually a telephone number you can phone when you have a problem? Price, of course, and the last point was not mentioned by any, but we put it on the list nevertheless, ecological footprint. Because again, I think this is a societal problem that we all want to think about. So, some key takeaways. AI innovation is not only about tech, it's also about culture and professional values. And by addressing ethical and legal challenges and creating a fair legal playing field, actually law can help innovation. And the AI Act, in its sense, is good and bad news because it does not regulate a lot journalistic AI, and because it does not regulate a lot journalistic AI. And whether the future of Gen AI is more of the same old big tech or something new also depends on you. What's next? So the Act is expected to enter into force in May when it's published in the official journal. A year later, the rules on Gen AI will kick in, and 2 years later, the whole thing is in force. And the real deal and also the real lobby is only starting now, when we actually carve out what all these rather vague norms really mean in the transparency template that we just discussed, in the code of practice for Gen AI providers, which in the end will very much depend how they will behave or not, but also in standardization. So what can you do? Let your voice be heard. If you have an interest in having trustworthy technology, procure responsibly, ask some tough questions before you start using a model. Strive for more. Think it's not only the law is just the bottom, but for the trust of society, of users in your product, you need to go beyond compliance and work together. And I think an event like this is a wonderful opportunity to bring everything together and start collaborating. Thank you so much.
Thank you so much, Natalie. And actually, this time the questions won't come from me, or maybe it will afterwards. But we have asked Anna Söder, Public Policy Manager at Schibsted, to comment on the AI Act from the company perspectives. So, Anna, you're sitting right here. You stand up. What are your reflections after listening to Natalie's presentation?
Oh, thank you, Marie. And
oh,
is this working? Thank you so much, Natalie, for a great presentation. As Marie said, I am Public Policy Manager for Schibsted, and what that means is that I'm actually a lobbyist. So I spent the last year lobbying the AI Act, and of course we've been monitoring this for some time now, and this will have, of course, implications for us. And Natalie, it's so great to hear your analysis on this. I think, when we started lobbying the AI Act, we were not focusing on the copyright issue. We were really concerned. We were more concerned about safeguarding our possibilities to actually be able to use generative AI and to build all of these amazing tools that we have seen examples of these 2 days. Because as Natalie said, when ChatGPT broke the internet, their discussions in Brussels were all about, introducing really heavy obligations on generative AI, irrespective of risk level. And we were also very concerned that, the legislator would introduce very descriptive transparency obligations that would state exactly how and when we were obliged to be transparent on the use of generative AI. And that would have been really, odd or unfortunate for us, since we're a business that is used to being self-regulated. And I mean, our take is, luckily, we did not end up with that. We ended up with a more balanced regulation on generative AI than we could have gotten. That's, our initial thought. And as, Natalie told us, we did not get any transparency obligations. And of course, that will not mean that we won't be transparent. It's part of our DNA. But, the legislator left it up to us to choose the when and the how. And that's something I think that we all should be grateful for. And Agnes will tell us more about, how the Swedish publishers have handled the issue of transparency. But I think there are parts of the AI Act that we definitely need to take a closer look at and do our homework. And that is, of course, when are we users of generative AI, and when do we actually become providers and are, need to be compliant with those types of rules. Even if it's not high risk, there are, as Natalie told us, some obligations that we still need to adhere to. And that is not clear, and that is something that I really would like to discuss with you afterwards. Because, if us just building a GPT on OpenAI, such as the buddy reader that Aftonbladet were talking about yesterday, then maybe, we're still users. But Schibsted, we build LLMs, and then we might become providers, and then we have a big set of obligations. So that's a big homework for us to do, and I think many of us in the room we need to take a closer look at this. And then there are, of course, parts of the AI Act or parts of the issues that the AI Act did not help us out so much with. And that is, for instance, the copyright issue. The relationship between copyright and the use of our data for training, that is not, that is an issue that we will need more guidance going forward. And also how we can be remunerated for that. That is something that we need to discuss. But I think it's difficult, or we should not just focus on the copyright remuneration for training data. We, as a business, need to discuss much more than we do today. What will the future of our business model look like in a very changed media landscape, and a potentially very changed media logic going forward? And that is a discussion that I miss when we get together like this. I think we should need to start talking about that. For instance, how can we be remunerated, for the use of our real-time data going forward? So I think that's a discussion for us to have.
Yeah, that is noted for the organizers as well. Natalie, would you like to come back on Anna's comment?
No, I think it's very great points. And it also relates to my last point about collaboration. You can all negotiate one by one, or you can collaborate. And I understood that in the Nordics there are already approaches to doing so, for example, from a Google case. Yeah.
But can I just ask, were there also a little bit of disappointment for not putting media for putting media in low risk? Would it have benefited us in some ways if we were to be demanded for some sort of, I don't know.
Answering that question in a room full of media
Yeah.
professionals is dangerous. Let me put it this way. The list is not definite. And of course, there is a lot of debate on the risk from synthetic media for democracy and fundamental rights. And the Commission can adjust the list. And for example, one application that has made it on the list in the very last moment is using AI in the context of elections to influence voting behavior. So you see already from where it is a small step to discussing issues about the use of AI in public discourse. So that is another point why it's so important to have self-regulation in place and to show that you deal with the technology responsibly, because this will probably ward off the regulator.
And it might be adjusted in that case.
Of course, it could be adjusted. So if there are a lot of problems of the use, I mean, I don't expect it, but if an industry goes rogue and does terrible things with technology, it will end up on the high risk category. So it's not excluded. It could end up there.
Okay. Thank you so much, Natali Helberger. Thank you, Anna Söder, for the comment.
Thank you.